A federal judge in Boston just blocked Trump's $100,000 H-1B visa fee. But the real story is not just immigration, it is executive power. The Trump administration argued the fee was a lawful immigration measure designed to discourage abuse of the H-1B visa system and protect American workers. Supporters say the program has been used by companies to replace American labor with cheaper foreign workers, especially in the tech industry. But Judge Leo Sorokin saw something else. In a 42-page ruling, he said the substance and application of the $100,000 payment revealed that it was a tax, no matter what the administration called it. And under the Constitution, taxes are supposed to come from Congress, not the White House. That distinction matters, because governments love changing the label on power. Call it a tax, and Congress has to vote. Call it a fee, a penalty, a surcharge, or a condition of entry, and suddenly the executive branch claims more room to act. But the court said this payment crossed the line. It was not just covering administrative costs, it was not just processing paperwork, it was a massive economic charge designed to change behavior. And that is why the judge vacated the policy entirely. Not narrowed it, not paused part of it, set it aside in full. The lawsuit came from 20 Democratic-led states which argued the fee would make it harder for hospitals, universities, and school systems to hire needed workers. Their argument was simple. Whatever you think about H-1B abuse and big tech, a $100,000 fee does not just hit giant corporations. It can also hit medical systems, public universities, and schools trying to fill jobs they already struggle to staff. And there is another detail that matters. As of February, USCIS has reportedly received only 85 payments under the fee. That suggests the policy was already creating resistance before this ruling. Employers were not exactly lining up to pay it. But this case is not over. Another federal judge in Washington, D.C. had already upheld the same fee in a separate lawsuit brought by the U.S. Chamber of Commerce. Judge Beryl Howell ruled that the policy fit within the president's broad immigration authority. That decision is being appealed. So now you have a split. One federal judge says the fee is lawful immigration policy, another says it is an unconstitutional tax. And that split matters because the question is bigger than H-1B visas. Can a president use immigration law to impose a six-figure payment that Congress never authorized? Judge Sorokin also cited the Supreme Court's recent tariff ruling against Trump, using similar logic. The president cannot use broad executive authority to create taxes that Congress never approved. That is the real pattern. Tariffs, visa fees, economic penalties. The administration keeps trying to reshape behavior through executive power, and courts keep asking the same question. Where did Congress authorize this? The White House says it is confident the ruling will be reversed on appeal, and maybe it will be. Courts are already divided. But for now, the Boston ruling draws a hard line. If the government wants to charge people $100,000, calling it a fee does not magically make it constitutional. And whether you support or oppose the H-1B program, that should matter. Because once presidents can create massive payments without Congress, the issue does not stay limited to immigration. A future president could use the same logic against energy companies, tech companies, banks, hospitals, schools, or any industry they want to pressure. That is why this ruling matters. Not because it settles the immigration debate. It does not. It matters because it asks a much older question. When the government takes your money, who actually has the power to say yes? Congress or the president with a new label?